We are recording.
All right, good afternoon, everyone. Welcome to the Appellate Court. I'm Judge Bright. I'm sitting this afternoon with Judge Albert and Judge Devlin on the matter of Giuliano versus Jefferson Radiology PC, AC docket numbers 42835. The hearing is being conducted over the Teams platform, which means we're all appearing via video conference. The matter is also being streamed live over the branch's YouTube channel. I'm going to ask everyone to introduce themselves just to make sure we can see and hear each other okay. I'll start with the judges, then counsel for the appellant, then counsel for the appellee. Again, I'm Judge Bright.
I'm Judge Albert.
I'm Judge Robert Devlin.
I'm John Williams on behalf of the plaintiff appellant.
Good afternoon. Kristen Connors, Stockman, O'Connor, and Connors on behalf of Jefferson Radiology and Dr. William Poole.
Okay, I can hear and see everyone okay. I assume that's true for everyone else. If at any time you're unable to hear anyone, please let us know. If you're unable to see anyone, please let us know. And if you get disconnected, please go back to the link and rejoin the argument. We will suspend the argument until we know that we have everyone present. I'm going to ask everybody to keep their microphones muted when they're not speaking to avoid any feedback and background noises. The judges are going to do the same, which means we're going to raise our hands if we have any questions and ask counsel to recognize us. If you don't, we will just jump in like we would in the courtroom. But again, we're trying to avoid the feedback. Would ask everyone to keep their cameras on at all times so that we can make sure you're present and appropriately engaged in the argument. I'll remind counsel that although we're doing this virtually, this is a court proceeding, and you should conduct yourself as if you were standing in the courtroom at 75 Elm Street here in Hartford. Each side will have 20 minutes to argue. The appellant can reserve some time for rebuttal. I will keep the time because we do not have our light system available to us. I will hold up a sign at 2 minutes, at 1 minute, and when time is up. And with that, I think we're ready to go. Attorney Williams, are you ready to proceed?
Yes, I am, Your Honor. If it please the court, I am John Williams on behalf of the plaintiff appellant. I'd like to reserve 5 minutes for rebuttal.
Okay, you may proceed.
Thank you. The two issues presented by this appeal have to do with testimony of two expert witnesses, one a designated opinion expert and the other a designated treating expert. The first of those witnesses was the very first witness called by the plaintiff at the start of the case, and that was Dr. Linda Griska. And from early on in the testimony of Dr. Griska, the court unaccountably and without providing any explanation sustained repeated objections, quote, objection as to form, and declined to state the basis on which those objections were sustained. And counsel for the defendant explicitly declined to state the actual basis for that so-called objection as to form. And when the plaintiff's attorney, who clearly was befuddled by this turn of events, attempted to get some clarification, she was told that if she didn't know what she was doing, she shouldn't have filed the suit in the first place, that it was up to her to know what was the right way to ask a question, and the court was not going to help her. She then requested a permission to have a brief recess so she could attempt to figure out what was going on. Defense counsel objected, and finally there was an agreement reached in which the plaintiff's attorney was not allowed to leave the courtroom, was not allowed to consult with the expert witness, and was in fact monitored by a member of the court clerical staff while attempting in the courtroom to figure out what was going on, which essentially was limited to attempting to use this isn't on the record, but attempted to use a cell phone to do some research. So that didn't work well. And the testimony of Dr. Griska on the first day of trial was a little less than a disaster. Meanwhile, plaintiff's attorney was humiliated repeatedly in front of the jury, not knowing what she was doing, with all that entails, as any experienced trial attorney knows. Now, the defense, the appellee here, makes the argument in reply that the following day, the judge changed her mind and fixed it. And it is true that the following day, those objections as to form, which were routinely granted the first day, were no longer granted. Again, no reason was stated. It just new rules, and so the defendant, the appellee, takes the position here that, well, no harm, no foul. And the question is there any harm? And there's harm in two ways here, which I think is apparent from the record. The first, of course, is the harm that I alluded to earlier, which is the common experience of any experienced trial attorney, that this lawyer was humiliated repeatedly in front of the jury, and the court did not make any sua sponte instruction to the jury, advising the jury not to be concerned, not to hold it against counsel, all of the usual things that trial judges do. And so counsel here was left in an impossible situation and truly humiliated in front of the jury, which undoubtedly would have an impact on her credibility the rest of the trial. The second way that harm appears connects to the second issue in the case, and that has to do with the treating expert, Dr. Leopold. The court had set a period of time during which this trial would have to be concluded. And if in effect, a half a day was lost to the plaintiff because of the things that the court did with Dr. Griska on the first day of trial. It was just a wasted day. And that then comes back to haunt the plaintiff and her attorney on the last day scheduled for the presentation of defense evidence, because it was on that day that Dr. Leopold was called, and in effect, counsel was told that you have literally a matter of minutes to present the testimony of this witness, and you're not getting any more. And indeed, as you can see from the trial transcript, when the court got to the point when, I guess, the time clock indicated something magical, the court actually interrupted counsel to say, you have one question left. And then, having reserved additional time for the defense to present their case, the defense, of course, said nothing. We have no questions. And so they're left with this period of time just hanging. Now, I suppose counsel is going to say, well, why didn't plaintiff's attorney ask for more time? I think that the only reasonable explanation, and again, I think it's the sort of thing that any experienced trial attorney would know, is that by that point, counsel was so intimidated, so humiliated, that she truly felt that she had no alternative but just to do what she was told. And that, of course, is what happened. I submit, therefore, that what we see in this... Yes, Your Honor.
Attorney Williams, am I correct that you were in the courtroom with counsel during all of this?
Not during all of this, no, Your Honor. I was in and out. I was brought in as a co-counsel for limited purposes at the beginning of the case that had to do with a number of preliminary motions. There were issues involving attempts to get evidence from other proceedings in, and I was asked to help plaintiff's attorney with some of those issues. But I was in and out of the courtroom during the trial. I was definitely not there the entire trial.
Okay, so you weren't there for this bit with Dr. Leopold at the end?
Oh, I to the best of my recollection, Your Honor, I was not. The transcript will be the best answer, but I do not believe I was in court that day.
Okay. I had another unrelated question. At the beginning of your argument, you said that defense counsel explicitly declined to state the basis for the objection to form. I did not see that in the parts of the transcript which you included in the appendix and quoted from in your brief. Can you tell me where in the transcript counsel has explicitly said, I'm not going to provide any further explanation other than objection to form?
I I don't believe those exact words do appear. I took that, the statement that I made to the court from the actual appendix, the portions of the transcript that appear in the appendix. I think that's a reasonable interpretation, because counsel, as you can see, actually was taking the position that she didn't want counsel to figure out where she had gone wrong, that she felt that that was counsel's problem, that she was not properly prepared, and too bad.
Well, but let me ask you a question. Let's say it wasn't an objection to form. Let's say it was an objection relevance. Don't trial judges typically say, I don't want speaking objections, state your objection, and then it's up for the other side to make a record and say, Your Honor, I'd like to be heard outside the presence of the jury to determine what the basis of the claim of relevance or the lack of relevance is, or what the objection to form is. Isn't that typically what happens?
Well, relevance, we all know what that means, but what does it mean when you say objection to form? That is a term, as we all know, that just isn't used in a courtroom. That's what we say at a deposition, where all objections except are reserved except as to form. And indeed, the way that a court would ordinarily handle someone standing up and say objecting to the form is the way this court did on the second day of trial. What are you talking about, counsel? What do you mean by that? State a ground for objection, which indeed is supposed to be done. And it's the obligation of an attorney, certainly not to have a speaking objection, not to give a summation to the jury, but to alert the court to the actual basis for its objection, the court and counsel, by the way. And that was not done, and it was not done repeatedly throughout the first day of the trial.
Did the plaintiff's counsel ever say, Judge, I'd like a better explanation as to the objection?
I think that plaintiff's counsel did not actually say that, but the court really precluded any such inquiry by stating on its own, as you can see in the transcript in the appendix, that I'm not going to tell you the basis for my ruling. I'm not going to tell you how to try your case. You should know already. There's procedures you're supposed to follow, and left it at that. So the court had already told counsel she wasn't going to tell her.
No, what the court said was, I'm not going to tell you what to do, which is different than say, I'm not going to explain the reason for my ruling. I mean, those are very two different things. And you equate them as being the same. Is that fair?
I do, Your Honor. I just have to respectfully disagree with Your Honor's interpretation of those words. I do equate them as being the same. And that's my argument here. I believe that this is one of those rare cases where we have a true abuse of discretion. This is in the context of these events that occurred at the beginning of the trial and at the end of the plaintiff's portion of the trial that combined constitute an abuse of discretion that really deprived this plaintiff of her right to have her day in court. And I know it's a rare case that is going to be reversed on that ground, but I respectfully submit that this is such a case. That's my argument.
All right, I see no further questions, so you'll have up to 8.5 minutes if you need it for rebuttal.
Thank you, Your Honor.
Okay. Attorney Connors, you ready to proceed? You're on mute. There you go.
Good afternoon. By way of background, as you know, this involves the trial of a medical malpractice claim to a jury before Judge Cobb. On March 19th, 2019, after opening statements, the plaintiff called her first witness, a radiologist, her standard of care expert witness named Linda Griska, Dr. Linda Griska. The direct exam of Dr. Griska occurred for the rest of the morning session after our opening statements, the entire afternoon session, and the majority of the second day. And as you can tell from the transcripts, ultimately, plaintiff's counsel was able to elicit the opinion testimony that she needed to survive a directed verdict. So as we can see from the testimony, plaintiff's counsel was able to elicit opinions from Dr. Griska that Dr. Poole had failed to identify microcalcifications in the bilateral mammogram that is the subject of this lawsuit. There was also a related right breast ultrasound, and that Dr. Poole had failed to take additional views. Plaintiff's counsel was also able to elicit the opinion from Dr. Griska that an additional ultrasound should have been taken. And the objections regarding the questioning were appropriately sustained. The plaintiff's counsel was apparently, before the start of the trial, unfamiliar with how it is in a medical malpractice matter that expert opinion testimony is elicited, that there are certain simple questions regarding whether the witness is familiar with the prevailing standard of care for a radiologist in 2012 under the circumstances of the plaintiff's care. And to state that, particularly when not present on the first day, that the attorney attempting to elicit this essential testimony was humiliated reflects the fact that Attorney Williams was not present that day. To the contrary, the court went out of its way, if you will, to allow plaintiff's counsel every opportunity to get the opinion testimony that she needed from Dr. Griska, what the standard of care was, what the breaches of the standard of care were. That was Dr. Griska's role in the case, and the court afforded plaintiff's counsel every opportunity. There was no humiliation. I was present. Plaintiff's counsel is anything but intimidated. She is a capable attorney, but so much so that there was a sidebar. Then when the plaintiff's counsel still could not formulate the questions the way she is required to, then there was a break. It's very ordinary for the trial judge to agree that the plaintiff's counsel should not confer with the expert during her testimony. And then not only was there a sidebar and a break, but then we had overnight. So Dr. Griska returned the next morning. It was clear, and perhaps you can see it as well in the transcripts, that overnight Dr. Griska had learned what the opinion, the required questions were of her. And she was prepared to give those. The questions by plaintiff's counsel, though, continued to still be inadequate. And again, Judge Cobb, not humiliating plaintiff's counsel at all. Again, from the transcript is clear where she states in front of the jury, it's not just any physician. And it was at that moment, after that statement by Judge Cobb, that plaintiff's counsel then was able to formulate the question in the way she needed to. A radiologist, 2012, the circumstances of the plaintiff's care and treatment, and then the exact opinions that plaintiff's counsel had always intended to obtain from Dr. Griska were obtained, and the jury heard those opinions. So the sustaining of the objections to the questioning of Dr. Griska were appropriate, and plaintiff failed to preserve her right to appeal those evidentiary issues. The objections were properly sustained, and then also, even if, and I do disagree with this, but even if sustaining of those objections were improper, it has no bearing on the outcome, because plaintiff's counsel was, as we just discussed, ultimately allowed to elicit the necessary opinion testimony of her expert on standard of care and what the alleged breaches of standard of care were. With regard to Dr. Leopold was disclosed as a subpoena-only expert. So that's the quote that's used in plaintiff's counsel's own disclosure of the expert witness of Dr. Leopold. He was not disclosed on causation. He was merely disclosed as a treating physician. That is in part related to the desire not to have to pay Dr. Leopold for his expert witness testimony and fees. And so plaintiff's counsel made a strategic decision to disclose a number of her treating physicians with this language of subpoena testimony only. And it was also the case that Dr. Leopold had limitations on the time where he could testify at court, and he provided an afternoon for that testimony. His medical records were of limited number of pages. The plaintiff's counsel, as you can tell from the transcript, was able to evoke from Dr. Leopold and for him to share with the jury all of the information that she needed from Dr. Leopold regarding his care and treatment. He's a radiation oncologist that the plaintiff had undergone. You can see from the transcript that the last question, which plaintiff needed from a causation expert, that objection was sustained because nowhere in Dr. Leopold's medical records was this idea of causation. And so plaintiff did not run out of time with Dr. Leopold. Plaintiff ran into difficulty in that she had chosen to disclose Dr. Leopold simply as a treating physician. That means, pursuant to our practice book 13-4B2, that he could only be asked questions, could only be asked opinions if those were clearly stated in his medical records. And what's not stated in his medical records, and therefore that's why he was not able to provide the ultimate causation opinion that plaintiff needed, was whether, and this is key again to a medical malpractice action, whether any alleged delay resulted in any additional harm to the plaintiff. So once it was clear that Judge Cobb would not allow opinion testimony from Dr. Leopold beyond what appeared in his medical records, again, because it was plaintiff's counsel's choice to merely disclose him as a treating physician, she was out of questions. And then to assure that there was no harm to the time allowed for Dr. Leopold, I chose to ask no questions whatsoever. At that point, if plaintiff's counsel had additional questions of Dr. Leopold, she had every opportunity to use all the time that had been put aside for my questioning to ask additional questions herself. And again, as we can tell from the transcripts, then Judge Cobb asked plaintiff's counsel, and she rests. The only thing that was to remain after that was an open issue regarding medical bills. So again, with the second issue about a time limit on Dr. Leopold, there was no time limit, in that there was still much opportunity for plaintiff's counsel to ask any of the questions that she was entitled to ask of a treating physician, but it was the case that she had completed her questions of a treating physician. It was just at this point in the trial, she had realized that she didn't have her necessary causation opinion from an oncologist, that any alleged delay could cause any additional harm to the plaintiff.
All right, seeing no questions from the panel, are you finished with your argument, Attorney Connors?
Yes, I am.
All right, Attorney Williams, you have 8.5 minutes.
I appreciate the time, but I have nothing to add at this point. I'll rest on my brief.
All right, thank you both very much for participating here today with us. We will take the matter under advisement, and we will stand in recess until 4 o'clock this afternoon. Have a good day.
Thank you.
Thank you.
Thank you.